Ladies and gentlemen, high quality often implies a lot of improvisation, and I developed some knowledge in that. And so, what is a good panel? And a panel is good when it's well prepared, or when it represents all voices on a particular topic, voices that speak, voices that have vision, voices that have an opinion. And so in this search for panels, we add people, we shift people from moderator roles to speaker roles, as we have done 2 days ago. Or we add people, and this is precisely what we did today. I think one of the central themes running through all the panels in this Grand Hall was the intelligence community, its approach to privacy, approaches to regulate that community, and so on. And we have added today, it's not in your program, but we have added a Belgian member of the oversight body on the intelligence community, which is Wouter de Ridder. It's a parliamentary institute in Belgium that is called Comité I of Intelligence. And by adding somebody from the intelligence community, we hope to make clear that this is not a place where only privacy proponents of speak, but we want to have all the voices, and if you discuss the intelligence communities, then they need to be present. So I think this panel has the right fit in the light of the other panels that equally had a right fit. It is moderated by somebody that I admire, because he has been working very hard also at this conference, Giovanni Buttarelli. He's going to I'm going to do some timekeeping, but Giovanni is going to lead the discussion. We will have William, who has already appeared. There was a movie and he was involved in, so I hope you enjoyed that movie. We have Robert, who is going to voice the intelligence community also. We have Paul, and I'm going to use the first names. I think the third day allows me to do that. Paul, who has kept us awake yesterday, and then Florence, who you arrived today, I guess, or you, oh yeah, she was there on Wednesday too. So, but we are gonna pursue this very difficult question that was raised this morning. The first panel in the morning, one of the speakers said, "Do not expect an international treaty on intelligence gathering," as if that was impossible. And that is precisely one of the questions on the table, on this table. What can we expect from that ideal of the rule of law when we turn towards the intelligence community? Will that be the end of the intelligence community? That is one of the questions. There are many more. They're all nicely identified in the programs, and I think Giovanni will further elaborate these questions before introducing the speakers properly. So Giovanni, please.
Good afternoon, everybody. Thank you for your introduction. As you can see, this panel is entitled to the well-known Caspar Bowden. In July last year, we have all been informed that he passed away. You are all familiar with his experience as tireless advocate of privacy and the freedom of individuals. So I think it has been a good idea to entitle to Caspar this panel, since the data protection community will miss his intellectual courage, his commitment, and you may still have opposite views about his personal character, his working style, but let me say that he had the force, and he used it for good purposes, and therefore that is his legacy to all of us, which we have paid tribute to this week, and which we need to continue to build. Having said that, you can see that this panel is rightly placed at the end of a sparkling conference, focusing on a very sensitive issue, intelligence and democracy. It has been a good idea, since once again this is a crucial moment for security. Once again, not only Europe but many countries are facing with serious threats. We are familiar with activities by government and international institutions they are all considering what measures, including new legislative acts or steps, are needed to prevent other brutal attacks. But at the same time, we need to focus on sustainable and long-term policies. This is not a temporary crisis in terms of security. And sustainability, of course, also means being true to our values in terms of fundamental rights and freedoms. So the legislators everywhere in and outside the European Union are now exploring various counter-terrorism options. Some of them are particularly relevant for the transatlantic dialogue between two strategic partners such as EU and US, although they are also relevant for the rest of the world. And I'm referring not only to what has been named yesterday the elephant in the room, the safe harbor, but also to the umbrella agreement and other bilateral exchanges of views, which also are to be arranged on the basis of an analysis of further uses of data. Last year, I had a chance in attending a conference on a similar issue to try to focus on, by limiting my analysis to EU and US, to some of the main issues where, notwithstanding the shared values and the way in which we both, on both sides of the ocean, proudly defend our system on privacy, there are objective differences to be considered. In any event, the debate is focusing on these areas. I'm referring to the legitimacy of bulk collection activities, what they mean in practice, particularly when they can be based on a temporary approach or perhaps targeted by using filters and specific limits. The debate, very well known to all of you, in between use versus collection of data, where the protection should start. The pendulum in between, confidentiality of surveillance activities in terms of efficiency and the expectation of a high level of transparency on what public authorities can do on data used for surveillance purposes. Redress mechanism is one other important area. And finally, I think one essential point also relates on data subjects who could be legitimately subject to these activities. Are we considering simply specific categories of suspected people, or by focusing, for instance, on metadata, should we give citizenships to limited, unlimited activities based on preventive processing activities of personal data? So we have distinguished colleagues around the panel, and I would like to refrain from making additional remarks and going immediately to the substance. We will start with an alphabetical order with William Binney. Your profile is very well known to the audience. It doesn't need of specific introduction. So I would like to ask all of you, with the first round of around 5 minutes, to break the ice, to focus on this area, so that perhaps in a second round we can go deeper. William, you have the floor.
Yeah, thank you. I'd like to show some slides just to get the base of the discussion started. This is working. Could I show the slides here?
It's there. Yeah, it's there.
It's there? It's there?
Yeah,
Okay. There we go. All right, this first slide just shows the acquisition system to collect massive amounts of data, content, and metadata around the world. This slide shows what they're doing inside the United States. This is the Fairview program. This is where they're collecting domestically content and metadata. And it shows there's over 100 taps. It's distributed right across the population of the United States. So the target is domestic. It's not foreign. If it were only foreign, it'd be along the coasts. Then these are the countries around the world that are participating. First, second, and third party. First party is U.S. The second party is listed there, and third parties. Only, I think, 7 or 8, according to the material I've been able to find in the web, are of third parties are participating in the fiber collection. Then all this data is fed into programs internally in NSA, and I would note or point at the lower left-hand corner there, FBI and CIA have direct access through the center at Quantico, Virginia of the FBI directly into these databases to pull out content as well as metadata. Without oversight, I might add. This is all being done under Executive Order 12333. And then this is what they claim is their reason for doing bulk acquisition, and they call this discovery or development, target development. Here their slide shows that traffic thief, which has the specific target database elements, metadata, if you will, of known targets around the world. That pulls that's the targeted selection right off the top, and they say that's low in terms of discovery. Then they go into this dictionary selected terms right there, into the pinwheel program. This is where they have all the massive amounts of text, and they go through a word search, and this is what basically dumps it dumps a Google-type search back on their analysts to try to figure it out, and that's why they can't surface. They can't figure out what's happening. That's why internally in NSA they're complaining, and I've got articles on that too, from Edward Snowden's material, showing that they can't see anything for this data. It's burying them. And they say information or data is not intelligence. What they're really saying is all this collection doesn't mean understanding of what you've collected. So you can't predict intentions and capabilities. You can't stop terrorist attacks before they occur. That's why they're failing every time. And yet every time they come back and say, we knew these people, well, the reason they're not doing is because they're buried in so much data. If they focused on the targets and did a targeted specific approach, they would have a very high potential of stopping these attacks before they happen and be able to save lives. Then down below that, they go into the Marina. Well, that's just the graphing of the index of the pinwheel database, and then they go to X-keyscore. That's where they get into other databases and other information, and all of this gets dumped on the analysts, and they can't surface from this orders of magnitude haystack that they're collecting. And then it's all trying to feed into this program called Treasure Map, where they want to read, or they want to follow every device on the network. That means they want to know where everybody is every minute of the day. Then they'll track your movements and everything, and here's how they do that. They look at the geographic layer and the physical network, the fibers, microwaves, satellites, everything, and then map it to the logical network of people communicating and map those to devices and then map it directly to the people. And that's how they want to follow everybody. My estimate was about 4 billion people on the planet every minute of every day. Then as a part of the further subversion of our democracy, what they're doing is using this data to go at people criminally. And these are the rules out of the Special Operations Division of the Drug Enforcement Administration as to how they're supposed to do that. And it says here you don't discuss these reports, you don't file any affidavits, you don't tell the attorneys, you don't tell the courts, you don't even tell the local and state law enforcement officials who perform the arrest, and most importantly, you don't tell your foreign counterparts. So this is a secret operation, and all of this has been done in a secret basically from the beginning. And then finally, in order to go into court, they have to do a parallel construction. And that simply means that they use normal policing techniques to go back and find out the same information. They already know where it is since they've got it from NSA and collaborating agencies. And then they use that in the court of law and pass it around the world through the MLAT agreements and use it to convict people. And this in turn is subverting our entire judicial process because this is actually perjury in a court of law. They're actually saying that the data, they're substituting data for the original data they They use to arrest people so that the defendant cannot challenge discovery. So they're denying the rights in that way. So it's a what I call a planned program perjury policy run by the Department of Justice of the United States. This is what happens when people get this kind of power in place. That collection of data on everybody is power over everybody, and they eventually use it. People are weak. They cannot resist using power. And simply put, this is what's happening to our democracies, and it's spreading. The U.S. started it in secret terms, and then spread it around to the U.K. and around the Five Eyes, and into other countries like Germany and so on. And now the Bundestag is finding out about what the BND is doing with NSA. And similarly, around other countries in Europe, they're going to find out other information is going on all this cooperation. And this is really subverting democracy around the world. This is really what concerns me. And the real point is that ultimately, bulk collection makes their analysts totally dysfunctional. They can't figure out anything in advance, so they can't do the job of intelligence, which is predicting intentions and capabilities, so that they have a chance to stop these attacks before they can happen. So saving lives. Instead, they have, by bulk collection, they're waiting for the attack to happen, then they go into the bulk data and find all the information they had on those people to begin with, when they should have focused on them in the beginning and not had the data on the rest of the people on the planet. So that's my concern. That's the focus I've had. I've been trying to tell different parliaments and governments around here in Europe the ways to do a targeted approach, and I certainly would be happy to do that to NSA or GCHQ too. Thank you.
Thank you. You will have a chance to further develop your messages in a second round. Paul, what about your feeling? You, in a way or in another one, represent here the guardian of a treaty in a European Union where, although we're not competent formally on national security in specific member states, but we are competent when national security activities in third member states, third countries may affect EU citizens, or in any event where certain activities in the EU go beyond certain limits. What's your feeling on this pendulum in between intelligence and democracy?
Well, thank you very much. I think, first of all, we're discussing here an issue which is not just a technical issue, it's a huge issue in the digital age and really pertains to very basic principles according to which we want to live, very basic principles of democracy. Does the state control the people, or do the people control the states and the governments? And I would also say that the jurisprudence which we have in Europe, not only the Schrems judgment, also Digital Rights Ireland and the European Court of Justice, but also the jurisprudence of the European Court of Human Rights, is very important in guiding us and in a way which allows us to maintain rights and values which must endure while technology moves on and has to move on. And the role in the European Commission of the European Commission in all this is very, very limited. As Giovanni just said, the treaty very clearly allocates national security to the member states. Of course, in the area of justice, liberty, and security, we have policies and laws in place on criminal law. But national security is a matter of member states, and therefore the Commission has to confine itself to only checking the proper use of the exemption clauses. And this is exactly what we're doing also in the safe harbor. We are in principle negotiating an agreement on commercial flows of data where we want to protect the personal data transferred to American companies in America, which under the safe harbor are treated like European companies, which is a huge privilege. And we're checking that this data is protected according to our standards. And the United States asks us to introduce into the commitments, or to accept that they introduce in the commitments which they give us on this count relating to personal data protection in the commercial context, an exemption clause for national security, And what we have to do according to the Schrems judgment is to check that this national security exemption is used in a way which is necessary and proportional for national security. And in doing this, we look to the jurisprudence not only of the European Court of Justice but also of the European Court of Human Rights. And let me say that it is probably European heritage to be suspicious of national security activities, and you find this suspicion and the threat to democracy over and over again in the jurisprudence. When you look at the European Court of Justice, it is very explicit about the chilling effect of data retention, of metadata, but even more of access to content, continuous bulk collection of content data. It is explicit about the interdiction of continuous bulk collection when it says that this continuous bulk collection of content data goes to the essence of the fundamental rights. It means it cannot happen in our democracy. And when we discuss here democracy, of course, what we really are discussing is the trias of democracy, rule of law, and fundamental rights. And in this trias, it is European heritage that after the experience of Auschwitz and the experience of the Gestapo, European countries have agreed to submit themselves to external control outside the country in the European Convention on Human Rights with a court to which every individual can turn to protect the individual against overreach of the state. This is European heritage, and in the jurisprudence of the European Court of Human Rights, we find many cases which guide us on the limitations, the necessary limitations to surveillance law going back as far as 1978. And we find there very clear statements. The Court of Human Rights tells us that we have to be aware of the danger such a law poses of undermining or even destroying democracy on the ground of defending it. These are words of the judges. This is 1978 already. In the more recent case law, the European Court of Human Rights has been very explicit about technological progress and its effect on freedom, and the need to develop protective laws and systems in parallel to the progress of technology. And again, very clear, in a field where abuse is potentially so easy in individual cases and could have such harmful consequences for democratic society as a whole, it is desirable to entrust supervision to a judge. So I think when we discuss here on this panel the relationship between democracy and surveillance and secret services, I think we have to note that at least in this European jurisprudence, there is incorporated a part of our heritage of Gestapo and Stasi spying, and I would say a healthy distrust to such laws and such activities, and therefore the need to put in place limitations in law, substantial limitations, but also procedural limitations which allow to ensure good judicial control, good democratic oversight, and protection of fundamental rights of the individuals. All these three things have to go hand in hand. And as I said, in the recent jurisprudence, even the new challenges resulting from technology progress are recognized. And so in our deliberations on how to structure limitations, substantial limitations, moving from bulk to targeted work of security services, which we of course need for the legitimate needs of security of our societies, but also in looking at the institutions which are called upon to exercise control functions, we have to take account of the increase of capacities through new technologies.
Thank you, Paul. We have here with us Robert Bob Litt, distinguished expert, senior counsel, is this the right job? General counsel at the NSA, and on the basis of your authority and seniority, perhaps you are the best place to say something about our concerns, for instance. To which extent EU concerns on third countries' surveillance activities are, correct or overstating? And what about recent developments you may decide to comment?
Thank you, Giovanni. Can you hear me on this?
Speak close to.
Is that better? Okay. So I'm actually going to talk a little bit about the question that is the topic of this panel, which is democratic control of intelligence agencies. I am not going to comment on anything in Mr. Binney's slideshow except to note that there were quite a number of factual, legal, and rhetorical errors, and you should not take everything that he said as being actual factual. There is this myth out there that intelligence agencies operate without the rule of law entirely on their own. And at least as applied to the United States, that is entirely a myth. Indeed, one of my colleagues has written an article in which he analogized the intelligence community to a regulated business. It is important when you're talking about oversight and legal control to differentiate between whether or not there is democratic oversight and control and whether or not you like the results of the process. Those are two different issues, and I think that there tends to be a confusion between the two of them. In fact, in the United States, our intelligence agencies operate within a very strict framework of law and multi-leveled oversight. Starting with the legal framework, it begins with our Constitution, and in particular the First and Fourth Amendments, and I gather there was some discussion earlier about the Fourth Amendment, and I want to make absolutely clear that the Fourth Amendment applies everywhere and at all times in the United States. There are a number of statutes governing the intelligence community that have been openly debated and passed by Congress. These include the National Security Act, the Foreign Intelligence Surveillance Act, the Electronic Communications Protection Act, and so on and so forth. There are executive orders which are issued by the President to govern the activity of intelligence agencies. These include Executive Order 12333 and Presidential Policy Directive 28. All of these govern what we do. How do we ensure that we comply with those legal rules? Well, the first step is that there are literally hundreds of lawyers and compliance officers throughout the intelligence community whose job it is to oversee, to audit, and to make sure that it's complied with. This book right here is called the Intelligence Community Legal Reference Book. It's some 12 or 1,300 pages long. These are the laws that myself and others like me have to ensure that the intelligence agencies follows, and we are involved in decision-making and ensuring that the laws are followed. My boss, I don't work for the NSA, I work for the Director of National Intelligence. He's charged by statute with ensuring that the activities of the intelligence community comply with the Constitution and laws. My office and other intelligence agencies have privacy protection officers whose job it is to look out for civil liberties and privacy. And the Department of Justice, which is outside of the intelligence community, has independent oversight functions to ensure that the laws are complied with. That's within the executive branch. Outside of the executive branch or independent from it, you have, first of all, inspectors general, who are statutorily created, statutorily deemed required to be independent. They report to Congress. They issue public reports, and you can go on the internet and easily find many reports of inspectors general that are highly critical of their agencies and have led to substantial changes in the activities of those agencies. We have the Privacy and Civil Liberties Oversight Board, which is an independent body that has access to classified information, has issued a number of thorough and comprehensive reports about United States intelligence activities. And if you want to understand the reality of how these activities work, I commend to you the Privacy and Civil Liberties Oversight Board reports. We then have a degree of judicial control as well. This operates particularly in the context of the Foreign Intelligence Surveillance Act, where we operate under the authority of the Foreign Intelligence Surveillance Court, which is a court of independent judges with life tenure. It is by no means a rubber stamp for the government. If you read their opinions that have been released, you can see that. Congress has recently provided for the appointment of public advocates within the court who can brief matters relating to privacy and civil liberties, and has mandated that their opinions, if they contain significant interpretations of law, become public. In addition, there's redress available for individuals who can show that they've been injured by violations of the law. They can go to court and obtain a judgment. Finally, we have Congress. In the 1970s, there was a move to reform how we oversaw intelligence. And this requires a difficult balance between the need to keep intelligence activities secret and the need to provide oversight. And the remedy, the approach that was taken by our Congress was the creation of two intelligence committees, one in our Senate and one in our House. And by law, they are required to have access to all intelligence information. We are required to keep them fully and currently informed of all intelligence activities, and we do. We're down there briefing them hundreds of times a year. We provide them notice of every significant activity. In addition, there are annual intelligence authorization bills which contain lengthy directions to us to do things. They fund things, they don't fund things, but Congress closely oversees our activities. And that's the manner in which the American people have determined that their publicly elected bodies should exercise oversight over intelligence activities. Finally, the one area in which until recently I think we have been deficient is in transparency with the public. I think it's fair to say that we drew the line in the wrong place on where we need to keep things secret to protect sources and methods. I think we're changing that now and recognizing that in order to continue to have public support for what we do, we have to be more transparent about our legal authorities, the operations, the manner in which we oversee our operations, the policies that govern us, and the protections we have for privacy and civil liberties. The bottom line is that using the framework that I articulated at the beginning, this oversight mechanism actually works very well. And if you look at the information that has come out about surveillance activities in the last couple of years, the first point to make is that Congress and the executive branch and the judicial branch were all aware of these programs. None of them was operated outside of law. They were all operated within the legal framework. And when there were mistakes made, they were brought to the attention of the courts and they were corrected. Secondly, there has been no evidence of abuse of these programs, no undermining of democracy, no suppression of dissent. They have only been used for legitimate foreign intelligence purposes, as they should be. Third, in fact, I think polls show that generally these programs are supported by the American public. And the result of these programs has been that we've been able to obtain useful intelligence information that we are even today funneling to European countries as well as using to protect our own citizens. And there have been a number of arrests over the course of the last year, and many of those have depended in part on intelligence information that we've obtained through our activities and shared with our partners.
Thank you, Bob. I think we will have a chance in a second round to also analyze the same item under another perspective. I mean, by assuming that there are no abuses and that intelligence agencies are building and following the legal order, but in a framework where perhaps is the legal order as such that can be controversial internationally speaking, or in case of specific agreements, decisions are to be taken. We decided at the last minute to enrich the panel and to rebalance it by focusing on an additional experience in terms of intelligence, since, as you know, some of the criticisms, particularly from outside the EU, relate to what we do in Europe in terms of proportionality and necessity of surveillance activities, particularly by intelligence agencies. And therefore, we have identified the very interesting profile of Wouter the Ritter, and I would ask you to introduce yourself, because you are the best place to give a snapshot of what your experience can inspire.
Thank you very much. Indeed, I know my name. It's Wouter the Ritter. I'm secretary of the I Committee since 1993, which was the year of coming into action of this new committee, which is a committee that has been mandated by law to oversight the two Belgian, of course, small intelligence agencies, one civil one and one military one, concerning the legality of their activities, but also the effectiveness and the coordination of their activities between agencies. My point of view is more focused as a practitioner on oversight, so less theoretical considerations, and our experience from the last almost 25 years turn around a topic which is extremely important in this item, that is the notion of secrecy. And of course, we have the classical explanation that since it concerns the fundamental interests of nation, it should be protected by secrecy. That is true, and I think everyone can understand in the struggle against terrorism that you can't get your actions or your operations into the newspapers. But also there is a nasty effect on this secrecy, that abuse can be facilitated by this secrecy. You can have individual abuses, structural abuses of all kinds. And another aspect of this is that you can't offer transparency to non-vetted, non-trained persons, and certainly not general public, of your methods, of your techniques, of your data. So this is a problem. And it becomes even more a problem when you think that the secrecy is not only working for these hard matters as a struggle against terrorism, but also for other fundamental interests of a country, its economic interests, its financial interests, energy questions, and so on, and so on, and so on. So abuses are possible, and the existence and the importance of secrecy has also another consequence, that it has developed a kind of culture or subculture, because there is a strict necessity of discretion and secrecy within the agencies, but that has a major part in the specific culture within agencies, which is not necessarily good or bad, it's just, I think, a fact that this culture exists. It could have also an effect on the vision of whether or not the agency's relations to law. And I must say I have seen a major, complete change in our Belgian situation when in the 90s there was no legal framework at all for the agencies, and even the agencies didn't want it to have, knowing very well that if there were standards, they could have been controlled. So is oversight impossible with this wall of secrecy around the functioning of the agencies? I'm convinced not. And I must say I have had years when I was in doubt. But now, for the last 10 years, we're making very good progress, and I see similar evolutions in other countries. What is necessary is that you understand as oversight the functioning, the machinery of intelligence, and the different disciplines of intelligence. There are many, many, many kind of very different jobs and techniques within the intelligence. And you can't be expert in everything, but you have to have a fundamental understanding on how an intelligence agency does work. And only with that you can get the respect and the recognition by the agencies, and you can get into a positive evolution of mutual respect and greater transparency. And that is an evolution that we have known in Belgium for the last 10, 15 years. So, is this all ideal now? Of course not. There is improvement to make on a legal basis. There is improvement to make in getting the young new members trained in the agencies, democratic, and get them used to democratic control. There is need for a better cooperation between different control authorities, whether parliament, expert groups like ours, or the judiciary. So one dimension which is for the most lacking until now is cooperation between oversight of different countries, and I think we can make further steps in the coming years, and we are trying very modestly with some colleagues of other European countries some steps forward to try to develop good practices of common investigations. So I would like to end over here.
Thank you, Wouter. Last but not least, we have a colleague from a data protection authority, the French one, currently chairing the network of European DPAs. And my question to you is not on what's going on in the work in progress analysis of recent developments, but to start with a question: who is entitled to assess necessity and proportionality? Why data protection independent administrative authorities have to play a role? And I think we may agree that similar analysis made by others, courts, politicians, law enforcement bodies can be based on an alternative result. But there is perhaps an objective approach that may allow these administrative authorities to reach the right point. What's your experience on this? We all know that the 29 Working Party has adopted in 2014 two documents on the galaxy of multiple legal instruments and judgments, and also recent experiences focusing on this area, and therefore have developed a sort of a decalogue of principles to be considered. What's your experience and what you see in the short term?
Thank you very much, Giovanni. So I think you have almost around 3 or 4 questions in the same sentence. But maybe if you allow me, I would like maybe to start with the question of the panel that was directed to the panel. And that was, if I remember correctly, whether intelligence and democracy was supposed to be mutually exclusive. And I think that the answer is clear. I mean, it's clearly no, that's not possible. And I guess that it's also a kind of wrong debate to oppose those two notions. I mean, it recalls me all the debates we had around privacy versus security, and if you have security, you have no privacy. If you have privacy, you have no security. The problem is how to combine and where you put the cursor. So it's about the balance between both, but not really to oppose them. And I would say that if you have, in fact, more surveillance and more intelligence, it requires also to have more, in fact, more guarantees about those kind of interference, and especially on privacy. And as Paul said, I mean, this dilemma is the daily job of the European judges that, in fact, have taken position on this problematic of democracy versus surveillance and intelligence for the last 40 or 30 years. So fortunately, we have some guidance, I mean, some solid basis to give solution to this problem. And the judge, I mean, it's quite interesting to see that the CGEU and the ECGH, the European Court on Human Rights, in fact, have quite a consistent approach with respect to interference to fundamental rights. I mean, they have established a jurisprudence and case law that are quite very similar to each other. So there is a great consistency between the two Supreme Courts at a European level, based on two texts of law that are of course, very key for us. Constitutional level, so the Charter and also the European Convention of Human Rights. So we have the highest level in terms of judges with the highest standards in terms of law that in fact are saying the same with respect to how do you manage interference to fundamental rights and to privacy. And the Schrems case, or the Severagor case, I don't know how to call it, is in fact the perfect illustration of that. But you have plenty of other case law that are going in the same direction. And so what the tests say, I guess it's quite important to recall what the judge say in terms of interference to fundamental rights. There are 4 essential guarantees. The first one is that you need to have a law. You need to have a law that frame this violation of fundamental right or this interference. That's the first guarantee. So interference is possible, but if you have first a legal basis, and why? What is the interest to have a law? It's because it needs to be foreseeable for the individual, for the citizen. People need to understand and to know under which circumstances and conditions the state will, in fact, interfere in their fundamental rights. The second one is necessarily and proportionality. We have talked a lot about that, and that's about, the targeting and all the bulk collection we have been discussing in different areas. So that's really also a key point. What is necessary, what is proportionate, but there is a need to have a kind of a balancing test about what is acceptable. And there is quite a strong statement in the Schrems case saying, legislation permitting public authority to have access must be regarded as compromising not only the right, but the essence of the fundamental right to respect for private life. It's a very, very strong statement about necessity and proportionality. The third one is independent oversight. There is a need to have an oversight, and you talked about this oversight, and how this oversight should be done, whether it's at the beginning, before the surveillance measure, or after, whether it should be done by an administrative or judicial order. But that's also a key element for us at European level. You need to have, in a certain way, a canon oversight. And the last one that is also absolutely fundamental for us, it's effective remedy. People need to have the possibility to go before a judge. And even if there is no proof for him, about surveillance measure or an intelligence measure against him. And that's a very key element for European citizens. So what's the relationship now with the Working Party 29 and what we are doing at the DPA level? The relationship, in fact, is very strong. The Schrems judge, the judge that ruled the Schrems case, talked about adequacy and Article 25. But in fact, the reasoning of the judge that is in fact taking this test I just talked about, these 4 essential guarantees, the test in fact is coming from something much bigger. It's the Charter and the Convention of Human Rights. And it doesn't apply only to adequacy. It's not a specific test just for the adequacy. It's a very broad test, and as Paul said, it's a test that he applied on several fundamental rights for the last 30 years. So it's something that's quite classical, and it applies also to the directive as a whole, and also to the Article 26 on sufficient safeguards. So that's why the Working Party 29 on October 16, after the judgment, quite logically said, whoa, we have to also to assess the impact on the other tools, on BCR and contractual clause that are sufficient, called sufficient safeguard under Article 26, because the ruling is going much further than just the adequacy. And so that's what we have been doing for at least 2 months, 3 months now. We have been really assessing, the impact of the ruling on those tools and whether they can be still considered in the light of this ruling as sufficient safeguard. And so that's why the test I talked about at the beginning, the judge test is so important to us because it's also the test that we need to take into consideration. So we did a whole work and really it was a collective work. And I know there is people in the room that have participated to this work. It was a huge work to assess all case law in Europe, Convention, the European Court of Human Rights, but also the CGEU, to define those guarantees, just to check for these guarantees, but also to assess US laws. So all surveillance intelligence laws, so 215, 702, PPD 28, and also Executive Order 12333. It was a huge work, and we thank also to the US authorities that participate also and help us to clarify some aspects. We have also consulted experts, external experts. We have sent letters. We have organized meetings. We have consultation with the business industry, with the civil society in EU, in US. It's a quite important work that has been done by the DPAs. And so now we will meet next week. So next week is, as you know, a very important meeting where we have to discuss together and to see what we draw from our analysis, what are the conclusions. And so as we need also to anticipate, we have also worked on if the assessment is negative, what do we do next? How do we launch enforcement action? What do we do with respect to prior authorization? That's a very important thing. It's important to understand that DPA have a power to, and have a duty, have a responsibility to authorize or not transfer to third country, and also to enforce the law, to apply the law. That's our job, that's our role. And so that's really something also that we have to decide, but collectively, and it's very important for the chair of the Working Party, it's to have a collective answer, not to have a divergent views on that. So it's an historical moment, and I remember on Wednesday we were talking about the regulation and also that we were in the middle of an historical moment as the regulation is just close to adoption. But it's also an historical moment for transfer for us. And so we hope to have a clear cut solution on Tuesday and Wednesday. Thank you.
Thank you, Florence. And this reminds me that last year CPDP 2015 took place a few days after the brutal attacks in Paris, so in a crucial moment in terms of counter-terrorism analysis, and this year as well. We all know that in parallel with this big event of CPDP, other important discussions are taking place internationally and particularly in Brussels. I would like now to open the floor for 2-3 questions before giving a final chance to the panelists to complete their thoughts. And who would like to be provocative enough to open the floor? 3 questions, I think, would be appropriate. Could you introduce yourself?
Hi, my name is Mark Rodenberg. I'm with EPIC. And first of all, actually, a fantastic panel. But I also want to acknowledge Bob Litt's participation, because for people who aren't familiar with Mr. Litt's role in the U.S. government, he's the General Counsel for the Office of the Director of National Intelligence, which is at the very top of the U.S. intelligence agency. And I'm not really going to debate him here. We've had many debates in the U.S., but I actually want to ask you this existential question.
I'm not very good at existentialism.
Well, I think this is an important one for you and for all of us, really. I mean, you have probably
Could you speak closer to the microphone?
You have probably had access to more threat information concerning genuine national security threats than any person in the world. You've probably also been aware of the development of more surveillance systems and more data gathering than any other person in the world. And it seems to me that the logic of the intelligence apparatus is to continue to accumulate information. We're no longer talking, of course, about databases. We're now talking about predictive analytics. We're talking about assigning scoring and risking to individual citizens based on their private activity. We are increasingly giving the decision-making of government over to processes and automated decision-making, which I think we barely understand. And my question to you is this: do you believe that 10 years from now, a person in your position could manage any meaningful accountability of this extraordinary apparatus that has been constructed in the early 21st century in the United States? Is that even possible?
Robert, take a breath. We collect other 2. I think the answer will be important. So we collect other 2. Who's first? The guy on the...
I've got a mic already.
Yes.
So,
do you get the microphone?
Giovanni, I'm sitting at the front with one.
Oh, you arrived first. Yes, I was looking on the right side. Okay, then it's you. Okay, please.
A much more Ian Brown from Oxford University. 2 much more specific questions to Mr. Litt. If you could clarify, I'd be interested. I'll be very interested to hear the Article 29 Working Party analysis of US law in this area. But you mentioned judicial remedies, and I know in a number of cases there have been problems with the state secrets doctrine. So if you could say a little bit more about that, the ability of Americans at least to get effective remedies in the US courts, given that. And then also I wonder if you could say a little bit more. You said the Fourth Amendment applies always and everywhere within the US, I think. What does that mean, say, to me as a European? What would my ability, if any, be to go to a US court to get a remedy against a US corporation that was processing my data?
Okay, Robert got 2 questions. He's thinking on the answer.
Yes, thank you.
Yes.
Andrew Adams from Major University. This question, any of the panelists could take this. I don't want to keep picking on Robert Litt there.
I'm used to it.
One of the principles of cryptography, Kirchhoff's principle from the 19th century, is that a secure system is one not in which the
Could you start over and speak a little louder? The kitchen is making a lot of racket back there.
Apologies. One of the principles of cryptography from the 19th century is Kirchhoff's principle that a secure system of cryptography is one not in which you don't know how it's encrypted, but one in which you only need to keep the keys secure. Could we not say that that's principle is a good one to try and apply to intelligence systems, so that it's not what they can do in general that we need to keep secret, because that we can't guarantee that that's kept secret, but that if we can say who they're looking at a specific time is all that we need to keep secret, we've got a much more robust system.
Okay, we got a final one. Then if we have time, after the second round, we can add an extra question.
Okay, Wouter van Holst, Vrijschrift. What I would like to hear from the panel is to what extent the exchange of data between the intelligence services does not constitute too much of a temptation for laundering and thereby escaping their individual oversight, and conversely, that the quid pro quo principle of exchanging data in itself does not provide too much of an incentive to over-collect in order to get enough exchange currency for exchange with other intelligence services.
Great. Regardless of the specific question, and any of you may add some few comments. We have 11 minutes, and we have to conclude sharp at 6:45. Who's the first?
So I'll actually address all questions, but in the reverse order. Starting with the last question, at least in the U.S., number one, we are not allowed to ask another intelligence service to do anything that we can't do. That's part of our legal regime. In terms of an incentive to over-collect, everything that we collect has to be justified by our own foreign intelligence requirements. So there's no incentive to over-collect in that regard. We do share information with foreign countries, but it's under fairly strict controls, and it cannot be and is not used to circumvent U.S. legal authorities. We rely upon other nations' intelligence services to apply the same rules to themselves. In terms of the question before that, I'm afraid I'm not familiar with Kerckhoffs's principle, but the general approach you take, I think, is exactly the one we're trying to do with respect to our transparency going forward, which is to say we need to protect our specific methods, we need to protect our specific targets, we need to protect the specific intelligence we're getting, but we need to be more transparent about, in general, what we're doing and how we're doing it. And I think you're exactly right. I don't know about doing it from a cryptographic point of view, but in terms of a public support point of view, which is essential to being able to continue our activities, I think that's the line we need to draw between what we disclose and what we don't disclose. In terms of the question about our legal system, on the Fourth Amendment, I guess as a technical matter, I'd say that neither an American nor a European would have a remedy against a corporation. You'd sue the government. You wouldn't sue the corporation. And it is true that generally speaking, the Fourth Amendment itself does not protect non-U.S. persons who are outside of the United States. If you're inside the United States, you would have a remedy. But a non-U.S. person outside the United States, our Constitution doesn't apply. You would have a remedy if it violates the Foreign Intelligence Surveillance Act or other provisions of U.S. law. As to Mark's question, I robustly deny the premises of your question about the extent of my knowledge. But having said that, my guess is the same question would have been asked 10 years ago, which is to say that as of 2016, do you think any person would be able to have a comprehensive oversight? And I think the answer to the question today, and probably the answer to the question to 10 years, is no one person will be able to have a detailed oversight. But through the entire mechanism of oversight, I think we will be able to maintain control over it. Things like predictive analytics, we're going to have to explain them to Congress. Congress has already imposed, as you know, a requirement that we report on data mining activities. I do think that we're going to move forward, perhaps in a halting manner, but that we will be able to continue to maintain effective oversight of the intelligence operation. I think we have to.
Thank you, Bob, for fairly leaving space to others. Mrs. Binney.
Yeah, I'd like to make a few comments about U.S. oversight and law. Even though I'm not a lawyer, I certainly know what several judges have ruled, and also the Second Circuit Court of Appeals have ruled basically that the secret interpretation of Section 215 of the Patriot Act is illegal. And so it's been illegal all along. That's why they tried to keep it secret. Secondly, I'd like to point out that as this program was first initially reported in the New York Times, Judge Robertson resigned from the FISA court because he knew he was being used as a puppet. And secondly, also as a follow-on to that, Judge Reggie Walton, who was the former head of the FISA court, after the Snowden material came out in August of 2013, he said to a CNN interview that he had limited capacity to validate anything that NSA or CIA or FBI were telling him. He could make sure they dotted the I's and crossed the T's and filled out all the forms, but he couldn't question or challenge anything they were saying in terms of the data they were presenting to get the warrant. That's the oversight part of it. And also the intelligence committees. I mean, they were originally formed under the Church Committee investigation into NSA for spying on U.S. citizens. NSA did the Minaret program, CIA did COINTELPRO, and CIA did CHAOS, and FBI did COINTELPRO. And they were spying on U.S. citizens, those that didn't conform to the administration's view. And that was a part of the investigation of the Church Committee. So the Church Committee then at that point formed the two intelligence committees, the House and Senate, and also the FISA court. The function of them was to ensure that they did not spy on U.S. citizens, when in fact those two committees are more advocates of spying on U.S. citizens than anything else. They're not opposing it, they're supporting it. So they become advocates of this bulk spying. So my point is that if you have, that none of them have any way of verifying anything the intelligence agencies are telling them. They have to simply take them at their word. They have no way of going into their databases or seeing what their analysts are really doing. For example, LoveInt, which was the love intelligence where NSA analysts were looking into the data, metadata, and content to see if their lovers or best wives were cheating on them. So that was done without, and NSA had no way that, they self-reported, otherwise they would never have known it. So, I mean, the point is that you need some effective oversight, and that requires some sort of technical invasion into these agencies by a cleared set of people, reporting back to all of the committees of Congress and all of the courts, not just a few, because that channels it through a limited number of points, and they can filter it and keep it from being spread. This is what's happened with these entire programs. They've been kept to very few people in the United States government, and it only came out, a lot of it came out with Snowden when all that material was released. So the point is you need to have that technical group be able to invade these spaces and verify what databases they have and what data they have in those bases. Otherwise, you can't trust them, and you can't verify anything they're doing.
Paul, it's your turn.
Well, I have actually very little to say on the questions. I can listen here.
That's hard to believe.
I can only listen here to everything which has been said. As I said, the Commission is very constrained in its analysis. We only look at the question, is the invocation of national security exemptions necessary and proportional? And there we look at the text of the law and the text of the commitments which we may or may not receive from the United States. To be very clear, we have no capacity to do the type of invasive checking. But I think what we want to have is text which reassures us that the strict requirements of the Schrems judgment, which is not a matter of proportionality, but it's a strict requirement that there is no continuous mass surveillance, bulk collection, that is complied with. And the second is that we have a fundamental right of individuals who can seek redress. This is a principle which I think we also need to see when our data is transported to the United States. So some mechanism, and the United States mentioned an ombudsman, which is independent and has the possibility to follow up complaints with the institutions which Robert mentioned. I think in this area, if we see that exists and works, then we can come to a finding that there is a proportionality and necessity. But whether that is possible to come to such a finding, we'll know over the weekend, because we're not there yet. We still need movement on the safe harbor. That is clear.
selective to be effective. I'm afraid you will have 1 minute each, but I'm sure you will be so concise and so persuasive.
In a very nutshell, of course. I'll give a mix of my convictions and response to the questions. I think there is a balance in every way. But finally, what do we want from, what do we expect of the agencies to do? Do we want them to prevent every single attack or not? I think it's impossible to have such high expectations. So we must be moderate also in our answers, but we must do our utmost best. But it's in the end also a democratic progress, but for a major part of it, it will be unpredictable because we are all victims of a situation which is for the moment not under control. But what we can do is to develop international standards. We can have better cooperations between the agencies and better cooperations between the oversight authorities. Thank you.
You have the final floor.
Just very quickly. I'm just thinking at the title of the communication, the Commission, I think 2 years ago, about restoring trust. And I guess the title is still very relevant in the sense that at the end, the goal, I mean, is to provide some level of trust to the citizens and to the customers. Our citizens, our people are feeling, I mean, at the same time they want to use the services, but also they have some expectation about the level they can, I mean, they can have in the US or in third country with respect to their privacy. So that's really the idea. How do we manage to provide this trust together? And when we go back to the guarantees, sorry to go back to the rules and to the church, but the 4 guarantees are quite justified. I mean, it's about, again, the law, it's about to be proportionate, it's about redress, and it's about oversight. That's something that, I guess, can be expected as a citizen when you are dealing with intelligence. Thank you.
Thank you, Florence. Thank you to all panelists. It has been a very interesting meeting. You want the last word.
No, it's just a thought occurred to me actually as Mr. Binney was speaking, that there's a point, Mark, that I should have made in answer to your question. And that is that I am, to some extent, a technological optimist. When people talk about technology in the context of surveillance, they tend to talk about either the terrible things NSA can do with technology or the ways you can use technology to protect yourself. I'm pretty confident that we can find technological ways to help us with oversight. I've read that there are ways, for example, that you can lock down databases so that you can put blind queries into them and you don't know anything in the database until the query comes out, and that this can provide for auditing. And I'm hopeful, and this goes to the point Mr. Binney made about access to databases. I don't know that we'll ever be able to allow people to have actual access to the databases themselves, but we may find technological ways to ensure that, in fact, the intelligence programs are operating within lawful bounds.
Interesting comment indeed. Again, thank you, everybody. We're now receiving colleagues from other panels. Thank you for your contribution. It's now the conference in the hands of Paul de Hert. Where is Paul?